Hey, what's up, YouTube? This is Beau Correll, just a neighborly, friendly, local personal injury attorney here. And I saw a deposition, at least a little bit of it today, on YouTube surfing, and I wanted to offer some commentary. I do depositions very frequently in my professional career, and let's just hop right in it because it's a little wild, a little bizarre, and it'll show you what not to do and how not to handle a deposition. So here we go. Let's pop this off.
Thomas Werge on behalf of plaintiff Justin Moskowitz.
Attorney Robert Abrams, license 37950, appearing pro se.
Neil Sullenberger, attorney registration 48698 for the firm.
Okay, you'll notice this is kind of unusual if you know what the term pro se means. Pro se means representing yourself.
Will the co-reported police swear to the deponent?
Sir, I'm going to ask you to raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
Thank you.
Good morning, Mr. Abrams. As you know, my name's Tom Werge. I'm counsel for plaintiff Justin Moskowitz in this lawsuit. And do you understand why you've been asked to give your deposition today?
No.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams and Associates?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I'm going to go ahead and stop there. You know, the beginning part of a deposition is one of the most important parts of the deposition. That's because you give the instructions. You first get informational, biography, what's your name, where do you reside, do you understand you are the defendant or a witness in this action? Very simple things, but you don't want to be argumentative. The introduction portion of a deposition is so important because it also manages the expectations, both of the deponent and you during the deposition. One of the things you don't want to do is have the person being deposed later say, well, I didn't understand the question. So during the instruction phase, you say such things as, hey, just want to be very clear here that if I ask a question, I'm going to assume you understand it. Is that fair? And you understand that you have the opportunity to say, I don't understand. And I will clarify my question during this deposition. Do you understand that? You don't want to be argumentative. I don't like the part where the plaintiff's lawyer is getting argumentative with the witness. But you're going to see a lot of argument back and forth during this.
Object to form.
I've answered that question. Object to form. Move on.
Now, he's saying object to form, move on. Usually the witness will never make objections. They either give their deposition or there is an objection by their attorney. Here's a very strange situation because the guy being deposed is a lawyer and he's choosing to represent himself. Let's keep going.
Mr. Abrams, have you been deposed?
Object to form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
Okay, special master in this context is basically a referee of the deposition. They rule on objections. So here the plaintiff's attorney would bring this matter to the attention of the special master, and the special master will rule. I think it's quite a trivial thing to bring up. Have you done a deposition before? Have you ever been a party to a lawsuit to try to call the special master? I think the plaintiff's lawyer should probably move on. But there is something to be said by laying down the law very early in a deposition, right? So you want to make certain that the witness doesn't get too crazy, and maybe he's trying to manage the behavior by setting an example early of this witness.
We're going off the record.
No, we're staying on the record, please.
Okay, very important. The other attorney says we're going off the record. You saw the video start to fade. But when you have an objection, you want to bring it to the attention of the judge. You want to say on the record so that the other attorney can't say anything inappropriate, that the witness can't say anything inappropriate, because that record is basically the transcript of the proceeding. So you want to make certain that the record is protected if you have a quarrelsome witness or party like this.
Would you be prepared to read back my answer to the special master regarding counsel's questions as to whether or not I answered that question?
Good morning. Could we speak with David Tenner, please?
I'm going to add, this is a really strange interplay here because you have the witness who is representing himself and another attorney interjecting into it. One of the things I would do very early on in a deposition like this is try to control the witness, is to say, okay, who will be making objections on the part of the deponent? If the deponent's a party or if they're representing themselves as a witness. It's very important to clarify because you don't want to be handling objections from two separate attorneys. You know, one here's the witness and an attorney representing themselves, and then the attorney for the law firm.
Please.
Let me check and see if you get Master's color.
Thank you. Yes, these are the parties from the Moskowitz versus Dahlman matter, and we are in the middle of a deposition this morning.
Okay, hold on just a moment.
Thank you.
He is not in the office at the moment. Can I get a number and have him call you back?
Yes, that would be great. If you could please.
Okay, I'll send him an email right now.
Appreciate it.
You're welcome.
Bye-bye. Mr.
Stay on the
Abrams.
record here.
Yeah, we're still
Oh, okay.
Yeah. Mr. Abrams, I want to ask you one more time. Have you had your deposition taken before?
Object to form.
Asked and answered, move on.
So it depends on the jurisdiction, but sometimes you say object to form, which is, you know, a basic objection that can handle different types of specific objections, and then clarify it later with the judge. But in a lot of other jurisdictions, you have to be very specific. You have to be timely, make the objection when it's due, and specific. You know, objection, hearsay, lack of foundation, expert opinion. Whatever it is, you have to be specific in some jurisdictions. Here it seems like form may be enough, but then occasionally I think you're going to hear some more specific objections. So, I mean, again, I would control this witness very early. I would say, who is the one making objections? I think that's very important because if it's not your client, why are you making objections?
You need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing
We're going to move for sanctions
I'm
against
asking you to
If you're not
answer
going
your
to
questions.
allow
He just
her-
answered the question.
He did not answer the question.
He just said he did not recall. That's an answer.
You know, at this point in time, what's the productive value here of keep asking the same question over again? It's clear he's not going to answer it. He's going to be combative. What you do is you just take a note as to the question he is being combative on and return to it later with the special master. When it comes to depositions, usually you can ask anything and they have to answer it. It's absolutely insane, but it's true. And then you bring it up to the judge or hear special master later to rule on the objection. That doesn't apply to privileged information in which you can instruct the witness not to answer. So in this particular situation, he's got to answer the question, and he's totally being inappropriate by not answering the question. And he's saying move on. He's not the judge here. So the deponent is totally in the wrong here.
I think so.
And when do you think that you were added as a defendant to a lawsuit in your individual capacity?
It may have been, if I get it right, it may have been in the BB matter.
So it's your testimony today you've been added, you were a defendant in a lawsuit in one matter, and that was the BB matter, is that
Objective
correct?
form.
I think they added me as an individual defendant, and they lost the case that went to jury trial.
Okay, so here it's a little bit unclear whether or not the plaintiff's attorney is asking questions because they want to determine the familiarity the witness has to giving a deposition. You know, the rules of the road of a deposition. If you've taken a deposition before, you understand I'm asking questions you have to answer under oath. Of course, this is a lawyer. He knows the answer to that. Or whether there's some other substantive reason he's asking these types of questions about another lawsuit. Remember, if it's not calculated to lead to admissible evidence at trial, it's kind of an improper line of questioning that at the end of the day, a jury wouldn't hear if it's not relevant and otherwise admissible. So, you know, you can ask questions, but it has to be calculated to try to lead to something that's admissible. So what I can imagine, or what should happen, is an objection be lodged. You know, objection, you can even say relevance or form, whatever it is, and then have the special master judge rule on it later, so it's not admissible in trial or otherwise used if this person is especially a party opponent. So let's move on.
And you said the other party was named BB?
Yes.
Okay. What was the other party's full name?
Sean Beeson. We call him BB. I represented him in a matter where him and his wife were both arrested for DUI. He was thrown in a drunk tank for being belligerent, and he sued the city. And then I put a restraining order on him for 9 months for attacking me in a stairwell. And then he sued, I can't remember if he sued me individually, but I think he did. And then he lost that suit outright at jury verdict. So we're going to move to strike that as irrelevant, object to form, and that it's going to lead to non-discoverable evidence. Under the rules of evidence.
Mr. Abrams, you are
Excuse me,
not
you can't
allowed
interrupt
to.
me.
I am allowed to interrupt you. This is my
he's
deposition
giving his answer.
sir.
You can't- it's
And
my
you,
answer.
it
This
is
is my
not.
answer.
You are not allowed to put objections on the record. You are a witness today. And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
It's very unclear what's actually happening because if you recall at the very beginning of the deposition, the deponent was stated by the court reporter to be pro se, meaning representing themselves. So again, it's unclear who's making objections here. If he's representing himself, then he can. Was he representing himself during the entire litigation? Very unclear.